first meeting of the Delaware Public Service Commission. It's nice to see so many other people in attendance. I think the first thing that we want to do is to get all the good news out of the way first. And we'd like to have Wayne come up here. Wayne, would you be kind enough to come up here? For those of you who do not know Wayne, he is in charge of our pipeline inspection and safety and program, and he just does a wonderful job. And he's also been here with us now for 5 years, and the state's very generous. They give a beautiful pin. And so I want to present that to Wayne. And more importantly, thank you. More important, thank you for your service and your assistance.
I couldn't do it without the other people.
We have a reading of the meeting minutes of July 10th. Are there any corrections or changes to those minutes? Commissioner Conaway.
Move we adopt the minutes of July 10th, 2024 as presented.
I second.
Is there any discussion on the motion? I don't believe that Commissioner Correa is going to be here either by phone or in person for a very necessary conflict that he has to take care of. And we wish him and his wife well and hope that she recovers. Having said that, we'll have Commissioner Conaway, how do you vote on the motion?
Aye.
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 One vote aye, the motion carries, the minutes are approved. We have public comment at this time. Is there anyone here who wishes to make public comment to the Public Service Commission? Unfortunately, we oftentimes have silence after that statement, and I wish we'd have a few more people show up and tell us what they're thinking, but it doesn't seem to happen very often.
I'll wait till I retire.
Thank you.
That just shows how much she's dying to come back the day after her retirement, right. So we have the consent agenda ahead of us now, and is there any commissioner wish any of the consent items to come off the consent agenda to the regular agenda?
Mr. Chair, I move that the Commission adopt the consent agenda as submitted.
Second the motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Aye. That's 4 ayes, 1 absent. The motion carries.
Mr. Chairman, may I request that whomever is tied in by phone to mute their devices because we can hear chatter in the hearing room?
Chairman Winslow, I also have a request for you to move closer to your mic.
Moved my mic around in the beginning because I didn't want to be heard before the meeting, and I will correct that. Thank you very much. The first item is in the matter of Axpo US LLC et al. Regarding the auction payments. And I do believe we have a slight amount of interest in this, and whoever is, I think we have, at least we used to have Kim Hoffman, who would be here. There she is. If you would lead this off, Ms. Hoffman, it'd be greatly appreciative.
Thank you, Mr. Chairman. My name is Kim Hoffman from Morris James, and I'm here with my co-counsel from Baker Botts, Michael Yuffie, and I would like to turn the presentation over to him at this time.
Welcome, Mr. Yucky.
Thank you, Mr. Chairman. As Ms. Hoffman said, my name is Michael Yuffie. I'm with Baker Botts in Washington, D.C., and here on behalf of the petitioners. I'm happy to make a presentation or to address any questions. The issue of jurisdiction that was raised in staff's supplemental comments came up yesterday, and so we're not prepared to address that jurisdictional question just yet, having it raised for the first time yesterday. But happy to go forward and make a presentation with respect to the other issues that we've raised in the petition or answer any questions. Happy to do it to music as well. Normally that's not the case.
There's to be no dancing, please. To repeat what Commissioner Gray said to all those out there in the Netherlands, if you'd be kind enough to mute your phones, that's M-U-T-E. Matt, how do we accomplish hang up everybody and come back online again? Here's what we're going to do, I think, unless my executive director tells me we can't. There we go. Someone woke up and is now present and on board and will now mute their telephone.
It's a possibility, Mr. Chair, that someone has put their line on hold, and that is what the fill has been that we are hearing.
Yeah, I guess there's a lot of possibilities, but the one thing we want to see happen is them to mute their telephones. Please, Mr. Yuffie,
Sure. So as I said, I'm happy to go through.
please do.
Okay, sure, absolutely, thank you. So the situation that we're facing is one of first impression, and one that was admittedly not anticipated by the terms of the FSA. The FSA doesn't address what happens when PJM recalculates the base residual auction for the price of capacity between the time of that Delaware would run the SOS auctions and the delivery year, because it's never happened before. PJM's never recalculated a base residual auction before. But that's what's happened here. So the result is that you've got one set of SOS suppliers who were subject expressly to a proxy price for use in the FSA because the base residual auction had not yet been run. And then a second subset of suppliers who participated in an SOS auction that was run once a price had been initially established by PJM, but has now been recalculated subsequent to the auction being run. And so you've got a situation where you have two groups of suppliers providing the exact same product that they pay the exact same price for, but yet are being paid two different prices under the agreement, which we believe is unduly discriminatory to those who, to the SOS suppliers who were not subject to the proxy price. The essence of the argument is that while the price might have been known at the time of this price of $66.07 per megawatt day might have been known, it really wasn't known because that's not the price anymore. And if you were to actually go on the PJM website, you couldn't find $66.07 anywhere on the website today. And so our position is that it's unduly discriminatory against the suppliers who, again, are paying currently are paying $175.22, which potentially is also subject to change. It could be recalculated as well, which begs the question of, is this price actually still known, right? For those SOS suppliers where there was a proxy price, they'll get a supplemental payment one way or another. It might be larger than, to make up the delta between the proxy price and 175 or less, depending upon if the $175 price remains. But nevertheless, our argument is that because the price wasn't actually known, it might have been perceived to have been known, but that's not the price. And the price for capacity in PJM can't change. It is one price for the delivery year. There's not an opportunity for there to be different prices for capacity within a delivery year. There's only one price. And staff and public advocate actually know this because they filed in their request for rehearing of FERC's order accepting PJM's position to recalculate the auction following the Third Circuit decision. Staff even took the position that the issue was the setting of the price, not that the price had changed, which is why they filed a complaint to change the price. So there's even a tacit understanding that the price can't change unless somebody files a 206, files a complaint at FERC saying that that price needs to change. This was all about the setting of the price. which gets to the issue of how do you treat Section 2.4 of the FSA? And what was that intended to cover? And Section 2.4 of the FSA basically says any changes in PJM pricing are to be borne by the suppliers. And what our position is that I think all the parties understood, again, because no party ever expected there to be changes to the base residual auction price. It had never happened since the first auction that was run nearly 20 years ago. And so that wasn't contemplated. What was contemplated were changes in energy pricing, changes in pricing associated with environmental attributes, as well as an understanding that the base residual auction price doesn't change, but the price for the final zonal net load price of capacity can change because of incremental auctions. And the notion was that those potential changes between the base residual auction price and incremental auction prices, those would be borne by suppliers, and suppliers understood that they had that risk. But I don't think anybody who executed the FSA or negotiated the FSA ever thought, oh, if there's going to be a recalculation of the base residual auction price, that should be borne by the suppliers. I don't think that was ever contemplated in establishing the language in the FSA. And so our position is that 2.4 is not dispositive because it doesn't address the intent of the contract. And the intent of the contract is to treat capacity as a pass-through. There have been suggestions that the suppliers could have incorporated risk premiums and can incorporate risk premiums associated with potential changes in capacity pricing. Again, you wouldn't include a risk premium for a risk you don't believe exists, because again, it had never happened before. But more importantly, if suppliers had included risk premiums, Delmarva would understand that. They'd know that. They'd be able to tell, based upon their review of the offers into the auction, they'd be able to assess, we are seeing pricing that looks like it's including risk premiums and perhaps the pricing that is not favorable, pricing that they would have issues with. So the idea that suppliers could have included risk premiums or would have included risk premiums, and that there's no way for Delmarva to know that is just not true. Delmarva would have a sense based upon what the auction price was and what the offers were. They'd be able to determine whether there were risk premiums that were included that were somehow reflective or not reflective of market conditions. At bottom, our position is that the party's intent is to treat capacity as a pass-through. It is inequitable, unduly discriminatory, it's unreasonable for Delmarva to pay $66 for capacity to one group of suppliers that they know has a value of $175, but to pay $175 to a different subset of suppliers, simply based upon timing that was focused on an unanticipated event. That the contract itself should reflect the party's intent, since there is no direct provision that we believe applies to the circumstances here.
Thank you very much. Who do we have next? We have Ms. Iori or Ms. Shen? Who's going to be the next?
I think probably staff might want to be the next one.
Okay.
Happy to do that, Mr. Chairman. Thank you. I think we have a threshold issue on the agenda today. It was a motion for my admission pro hoc vitae, which before I speak, probably needs to be acted on. Okay, so I'm free to go.
Excuse me, can you introduce yourself for us, please? Introduce yourself for me.
Yes, I'm Robert A. Weissart Jr., McNeese, Wallace, and Nurick on behalf of Commission staff. I want to start by addressing the jurisdictional issues that staff raised in supplemental comments. That's a threshold issue for the Commission. It is, after we reviewed the various comments that have been filed to date, it was not clear that the commission has jurisdiction to decide what is really a wholesale power supply agreement contract interpretation issue. Those contractual interpretation issues at the wholesale level lie either with the Federal Energy Regulatory Commission or a state or federal court. And I think this commission's jurisdiction is limited then to the pass-through of those resulting prices or costs to Delmarva's customers. And that is the scope of the commission's jurisdiction. And if you look at the FSA, there are certain sections that speak to the jurisdictional issue. It speaks to dispute resolution. It references the possibility that disputes under the FSA will be taken to state or federal court or to FERC. And there is also language in Section 1610 that speaks to the standard that applies to the contract. That standard is very much a FERC standard. It was a standard that was determined by the U.S. Supreme Court as a consequence of certain FERC decisions. So as the record sits right now, staff has concerns about whether the commission has jurisdiction to decide the issues that are teed up in the petition. We recommended what we thought was a fairly sensible process to give petitioners an opportunity to address those issues in supplemental comments, and then give other parties an opportunity to respond and tee this up again at the August 21st Commission public meeting. So that's staff's primary recommendation at this point. Because Mr. Yaffe raised the issues of sort of the merits of the petition, I'm happy to address those if you'd like, or we can defer those for another day.
Commissioners, do you have any preference on that? Excuse me.
Mr. Chair, I may have a question for clarification. Did I hear you say there may be two layers here? One is the contract for wholesale, and the other is the pass-through of the price. Can you elaborate a little more specifically how you distinguish in both cases?
Yeah, so in the commission's prior orders, when it looked at the RFP and then the FSA that are promulgated for procurement of SOS supply, that's for the perspective of essentially giving Delmarva cover or regulatory protection for the ultimate pass-through of those costs. So if the FSA is complied with, then Delmarva is able to recover those costs from customers. If the RFP is conducted consistent with the ordered RFP, Delmarva may recover those costs from customers. Those orders don't address the issue, though, of what happens if the RFP is not complied with, or if a dispute arises relative to Delmarva's obligations under the FSA. And those are issues that are, at least in staff's view, should be addressed in another forum. Those are not necessarily within the commission's jurisdiction. But if we play this out, let's say Delmarva, the petitioners, take that issue to another forum, and that other forum says the capacity price should be $175 and not $66. Then it comes back to this commission, and I think the commission at that point would be duty-bound to pass through a capacity price of $175. And if that other forum says the capacity price should be $66, then I think in that point, Delmarva has done its due diligence, and the cost pass-through remains at $66. Hopefully that helps.
I think it does. So you basically, in my view, are saying that we, the commission, are not party to the contract, therefore we have no standing to resolve issues related thereto?
I'm not saying that the commission wouldn't have standing to seek intervention in a state or federal court proceeding that involves contract interpretation issues, or wouldn't have standing to file a motion to intervene in a FERC proceeding involving that contractual dispute.
Thank you, Mr. Chair. No further questions.
Thank you, sir. Ms. Shen?
Good afternoon, Zishang Shen on behalf of Delmarva Power. I wanted to ask if the commission wanted me to address specific comments from the staff regarding jurisdiction or address the merits of the petition.
I would like to hear your discussion on the jurisdictional issue as well.
Sure. So at this time, Delmarva does not oppose staff supplemental comments and the proposed schedule that's laid out in the filing. I believe the schedule was August 7th for petitioner's submission and then August 14th for other parties to file any response. I think right now, we're looking at the arguments, we think there could be an argument that the commission lacks jurisdiction or is not the only body with jurisdiction. But at this time, we don't oppose staff's proposed schedule.
Thank you. Mr. Yuffie?
I mean, we also do not oppose staff's proposed order that would give us time to consider the jurisdictional argument and provide comments in response to it.
Yes, is there anyone else that I think we've hit everybody, right? My impression of the situation is that we have one commissioner short, and I think it's some pretty intense thought needs to be put into these issues, and I don't think I've seen anybody better parse language than the lawyers in this case, and since the Clinton administration, when perhaps it was a more exciting conversation. So I think that if we were to abide by the recommendation of the staff and put this off for further input, would be a wise thing to do. So I would move that we do that, and I would like to hear from the commissioners if they have any opposition to that or any other ideas before we do that.
I agree with you, Mr. Chair. It looks like I'm looking at an order 10490, which would, on the record, go down that lane. So if you're prepared for a motion.
Okay, any other comments?
I concur. I don't think that we can make any decisions until we determine whether we can make those decisions. So it's obviously the matter should be moved to the 27th.
I concur.
So we're gonna move it to August the 7th, did you say? And so, and then the parties will have to have their comments in by the 7th.
Point of order question, Mr. Chair. Matt, is this order going to memorialize and administer that approach?
Yes, there's actually two steps. There's an August 7th deadline for the suppliers, and then a reply period for the other parties, which I believe is the 14th, and then you would hear this again on the 21st.
Okay, that's what I read into the order. So, Mr. Chairman, I move that the commission adopt order number 10490 as submitted.
I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Aye. Motion carries, all four present, voting aye. Thank you very much. Mr. Yuffie, nice to meet you, sir.
Nice to meet you as well. Thank you.
Thank you.
Are you going to have another cameo appearance in August with us, Mr. Weishauer?
Yes, Mr. Chairman, I look
Good, terrific, thank you very much. Number 2 is in the matter of the regulation establishing the minimum filing requirements for all regulated companies subject to the jurisdiction of the Public Service Commission. And I believe we have Mr. Jordan, who's going to kick this off for us.
Good afternoon, Mr. Chair, Commissioners. Brian Jordan on behalf of Delmarva Power and Light Company. And may it please the Commission, we're here to discuss Delmarva's recent petition asking the Commission to open the docket to promulgate new regulations. To be clear, this is not a rate recovery filing. What the petition is asking is that we promulgate a regulation that designates Delmarva Power and Light as a pilot utility in the state of Delaware that would allow Delmarva to subsequently file a rate application that uses a historical test year to forecast up to 3 12-month periods called a rate year. Similar to the current rate applications that the company files, each rate year would seek rate-based rate of return recovery based off of the historical test year forecast. Delmarva cannot file this under the existing minimum filing requirements because the test period is limited to no more than 9 months projected. So, Delmarva has proposed this regulation that would allow a test period of up to 36 months projected. To be clear, this is an alternative to, it's not a replacement of the existing minimum filing requirements. And this regulation, if adopted, would not displace, it would not alter, it would not affect any of the parties' rights, nor would it affect the Commission's oversight and regulatory authority over Delmarva Power. That remains the same. And what the Commission is faced with today is the process to get to that subsequent filing. And the Commission has two orders, competing orders before it. The first order from Delmarva is proposed order number 10503. This is the Title 29 process. The Title 29 process, as the Commission knows, is a past proven process under the Administrative Procedures Act. It's applicable to all state agencies, and it provides a known, reliable process that this Commission has used previously, including to supplement the same minimum filing requirements about a year ago. And in fact, the Commission has used the Title 29 process 4 times this year already, in docket 49, 65, 66, and in docket 18-0935, which is currently under consideration using the Title 29 process. The second option is the Title 26 process. This is the process that staff and the public advocate have proposed. It is an unproven, unknown process, and it's one that would ultimately require the Commission to misinterpret the language of 201E, identify a conflict between the Commission's regulations and its Enabling Act, waive the conflict, just to get to where the Title 29 process takes us without all of that baggage. Now, of these two processes, Title 29 produces the most reliable and known and transparent product. So I'm going to go through a little bit of the Title 29 process and then discuss the opposition that was filed, and in the end, ask that the Commission adopt the proposed order 10503. Now, discussing the Title 29 process, I'm also going to discuss a little bit about what the AFRR regulation is that the company is seeking. But I'm not going to go into the details unless the Commission has specific questions for me on that. The best way to conceive of the Title 29 process is a 3-phase process. We're at phase 1. This is where the Commission or any state agency is asked to open a notice and comment period for the proposed regulation. Step 2 is the actual promulgation of the proposed regulation. This is when members of the public can comment on it. And there's other procedural mechanisms whereby the state agency gets informed about the regulation before it makes a decision. That decision ends phase 2. That decision, the state agency either adopts the regulation as proposed, adopts the regulation as amended, or denies the regulation. Phase 3, for our purposes, would be if the Commission ultimately approves the regulation and Delmarva then takes the step to file as the pilot utility an application for rate recovery using a fully forecasted period. The Title 29 process, as I mentioned, is familiar to the Commission, but it bears mentioning that it sets the bare minimums on things like timing, public participation, and notice that not just the Commission but any state agency must provide when promulgating a regulation. For timing, it requires a minimum of 30 days, where that period is open for the public to comment. If the Commission or any state agency opts to have a public hearing, it adds an additional 15 days. Now, in our application, we enlarged that time period to 108 days, from September 1st, 2024, to a public hearing December 18th, 2024. And the public comment period would extend it an additional time for a total of 129 days. Public participation under the Title 29 process is open and transparent. Anyone and everyone in the state of Delaware or outside can comment during that period. Importantly, Anyone who wishes to participate does not have to seek permission from the commission, does not have to file a motion to intervene that identifies their interest and why that interest is not already represented, which they would have to do with Title 26. The concern there is it could freeze out certain agencies, other agencies, from filing comments. In addition, small businesses and nonprofits could also submit comments during this period without having to hire an attorney, which they would probably have to do with the Title 26 process. There's also the notice requirement, and we included a proposed notice that set dates for the events I mentioned earlier, the public hearing and the end of the comment period. Now, staff and the public advocate in their opposition accused the company of shortchanging them, providing less than 180 days in Section 201E. But Title 29 does not prevent the commission from actually enlarging that time period. And in fact, if that is a concern, Delmarva is certainly happy to enlarge it. We could change the public comment period in the proposed notice to March 19th, 2025. Change the public hearing date to February 19th, 2025. That would make it a 199-day period. And that's just the public comment period. The commission would still have the time to consider and make its decision. The only restriction in Title 29 is that if the commission doesn't act within 12 months of the public hearing, the regulation is denied. So there's time. We can make this, we can provide the 180 days, we can provide more than the 180 days in the Title 26 process. Title 29 can accommodate those requests. Title 29 also is transparent, and it provides for a public hearing if the commission decides to appoint one. It also allows the commission to appoint a hearing examiner. And the process that the company is proposing would have the commission adopt a hearing examiner. This would be similar to the process used to amend the regulations a year ago when hearing examiner Kenton took charge and oversaw the process. So we're asking, it's a similar process, but it's slightly different because what we can do with Title 29 is, in fact, even more transparent because despite what staff and the DPA say in their opposition that they cannot submit testimony, that's incorrect. Under Title 29, specifically Section 10116, the hearing examiner or the commission can receive, quote, all written suggestions, compilations of data, briefs, or other written materials submitted to it by any person, end quote. That includes testimony, and if that wasn't clear, under Title 29, Section 10117, which addresses how a public hearing should be conducted, it says the commission or the hearing examiner, that's subsection B, is authorized to administer oaths to witnesses. That means testimony. As for cross-examination, at the public hearing, subsection C says the hearing examiner is authorized to, quote, exclude irrelevant, immaterial, insubstantial, cumulative, privileged matter, and unduly repetitive proofs, rebuttals, and cross-examination. That means the hearing examiner or the commission can allow for cross-examination. It just can't be duplicative or repetitive or redundant. But there is the opportunity for cross-examination, and it's not just like it would be in Title 26 where somebody has been granted a motion to intervene. It would be for anybody who has submitted the public comment. It would be overseen by the hearing examiner. And what we're also asking is that once the public comment period concludes, the hearing examiner would issue a recommendation similar to what hearing examiner Kenton did that sets out a recommendation about how the commission should act. It's a process the commission knows. It's the same we do for most of our contested matters and when there's a hearing examiner involved. So in other words, the idea that Title 29 somehow skirts protections for the public, whether it's in the public interest or fair and reasonable rates, is inaccurate. Title 29 promotes those. It allows us more in the way than Title 26 would. Now, when we turn our attention to the opposition that the public advocate and staff filed, they propose a different path, this Title 26 path. And in paragraph 4 of their opposition, they cite the statutory language at 201 subsection E. And helpfully, they put it in bold italics, and the section says, quote, "The Commission is specifically authorized to depart from rate base, rate of return regulation when it is in the public interest and when such departure is found to promote just and reasonable rates." Before going down that path, I think the Commission needs to look at how it's going to address it. First, should it take that language at face value? And if you do, I think you're quickly going to realize that you find yourself in quicksand. As staff and the DPA recognize in their opposition, the Commission has to take the remarkable step for which I could find no precedent, where a state agency says there is a conflict between the regulation it promulgated and the state statute. So how do they overcome that conflict? They cite to a 2018 case by Judge Clark that involved the DENREC regulation that conflicted with the Delaware Constitution, the federal Constitution, and state statutes about carrying firearms in state parks. And they cited it for the basic legal principle that when there's a conflict between a statute and a regulation, the statute wins. So therefore, under Section 201E, having said you're in conflict with yourself, you can waive that conflict. For proof, they point to an instance with our last rate case where Delmarva sought to waive parts of the minimum filing requirements. But what's important there, there's 4 items that we sought to waive. None of them involved a conflict with a statute. What they involved was a waiver because generation information was not relevant to that case. It was a waiver that we did not have to produce an Excel spreadsheet in paper form because it would be voluminous. And it was a waiver that sought a temporary stay because the data was not available until later. Again, no conflict there between a regulation and a statute. But I think the better example of a waiver that was not included would involve the electric ISR amendments that are before the Commission later today. As you recall, back in February, March of this year, the Commission waived the meet and confer process and the ISR process. But once again, it was not waiving a conflict. And more importantly, that was under the Title 29 process, not the Title 26 process. So ultimately, if the Commission declares that a conflict exists, a reviewing court is going to question, well, has that conflict existed for as long as the regulation and the statute have coexisted? And then why waive the conflict instead of resolving it like you can through the Title 29 process? After all, the same Judge Clark who issued the decision cited earlier issued a court opinion in April of this year stating that, quote, "An agency that lawfully adopts a regulation must follow its own regulations." So staff in the DPA's opposition puts the Commission in the unenviable position of having to answer that question, but there's no need to go that far. There's no need to engage in that pretzel logic because the Commission does not have to interpret Section 201E on its face value. The reality is it simply does not apply to what the company is seeking to do. Now, in the opposition, the public advocate and staff said it's not necessary for the Commission to get deeply into the specifics of the petition or the attached pre-file testimony, which is correct because when you read the actual proposed regulation, what it reveals is that we're not seeking to depart from, quote, rate-based rate of return regulation. The ultimate end product of the regulation Delmarva is proposing would adhere to the rate-based rate of return regulation. All it does is it extends that forecasted period from 9 months to 36 months. It does not affect and it does not apply with what there is in 201E. So under that reading, there is no conflict. The Commission doesn't have to resolve a conflict between 201E and the minimum filing requirements or the proposed regulation because 201E, by its statutory text, does not apply to this matter. Now, I also looked and researched 201E's legislative history to see if that provides any assistance. That context is important. So Section 201E actually started out as 201D back in 1995. And at the time it was originally enacted, the sponsor in its synopsis made clear that this text was intended to further deregulation and move away from rate base of return to competitive market pricing, think third-party suppliers. That legislative history says, and I quote, "Many public utilities are now faced with increasing competition in areas where they had previously enjoyed monopoly status, and regulatory reform is necessary to ensure that utility services are still provided economically to the regulated customer, while at the same time the utilities are allowed to offer competitive services in a deregulated environment." This legislation, talking about Section 201D at the time, it later became 201E, this legislation explicitly authorizes the Public Service Commission to deregulate public utilities, in whole or in part, when the commission determines that a competitive market exists and deregulation is in the public interest. In plain English, that means the text and context of Section 201E do not apply here. So if the sort of legal loop-de-loos that the commission would have to go through under this Title 201, Title 26 process did not give the commission cold feet earlier, the text and the context of Section 201E should eliminate any questions about its use. There's also a complaint in the opposition that these proposed minimum filing requirements are too complicated, particularly when they would only apply to Delmarva Power, no other public utility. Staff and the public advocate write that the multitude of challenges or changes to the MFRs that Delmarva proposes demonstrates just how complex and cumbersome, even if those changes are limited to Delmarva as a pilot in quotes. Now, that's an important note. And admittedly, when Delmarva first met with the public advocate and staff in June of this year, it did not include the pilot utility concept in the regulation it was going to propose. It quickly met firm resistance that had this regulation been available to every public utility in the state, there's a threat that they would all rush to the door to file one of these and overwhelm limited resources. So in response to that, Delmarva inserted the pilot utility concept, meaning it would be available, if approved, to Delmarva Power when it seeks an electric rate base application or a gas base rate application. And that concept's important too because it would allow for lessons learned afterwards. It's ultimately a discredit to the commission too to say that these regulations are too complicated. As mentioned, the commission has relied on this Title 29 process to supplement these same minimum filing requirements a year ago. In addition, Delmarva attached with its application the proposed regulation with all the legwork done, meaning all the commission would have to do would be submitted to the Register of Regulations. It follows the administrative style manual that the Register puts out, and it's ready to go. So the idea that it's too complex is also just not accurate. But ultimately, what's the end process with a Section 201E? Is it better than Title 29? And the answer there again is no. It creates an inefficiency. For these purposes, the end product of the Title 29 process is a regulation that goes to the Register and ultimately gets put into place. With Title 26, the opposition suggests that what Delmarva has to do is prepare an AFRR, or prepare one of these new filings, first for approval from the Commission to proceed, if you waive that language in the minimum filing requirements. That process would include data request, testimony, and if approved, Delmarva would then refile the same plan with the Commission, except this time for recovery. So we would be doing the same thing twice, and by we, I mean not just Delmarva, but the public advocate and staff. Or does Title 26 result in a recommendation to draft a new minimum filing requirement? Well, that's what we're doing here right now. We're proposing these alternatives to the traditional base or the traditional case. Title 29 process cuts through all of those redundancies and makes it clear that it is the straight path from A to B. Now, ultimately, if approved, and Delmarva were to file one of these applications, as I mentioned, the historical test year does not change. That definition is not changed. It's the same that the Commission's familiar with, that we use today. Now, there are a few items in the proposed regulation that are new concepts to the rate recovery process, including what's called an earnings sharing mechanism, or ESM. The ESM creates a deadband. So if the recovery of rates, if the company were to over-recover or under-recover outside of this commission-approved deadband, there's a process to either refund or recoup the rates. That would be filed each rate year. There's also an opportunity for what are called performance incentive mechanisms, or PIMs. These are mechanisms that are proposed by the company, subject to commission approval, and they would incentivize performance through various rewards. One example would be, as the commission knows, the company is currently replacing its cast iron main program in Newcastle County. The commission, to incentivize completion, could say, you know, it must be done by 2027, but if you complete it in 2026, you get this. If you complete it in 2025, you get this. Again, that's just an example of one of these things. Again, it would be subject to commission approval. Now, ultimately, though, there's nothing in the proposed regulation or the Title 29 process, like I said, that changes any party's rights or the commission's oversight. At the time Delmarva would file one of these, it still has the burden of proof to show that the rates are just and reasonable. The difference is it comes now at stage 3 of the Title 29 process. At the end of the Title 29 process, there was some discussion in the opposition about the public interest and whether Delmarva was trying to avoid that. It's not. The Title 29 process itself is in the public interest. In addition to everything that I discussed, including timing, participation, and so on, Title 29 requires an end product that includes, this is in section 10118, a brief summary of the evidence and information submitted, a brief summary of the Commission's findings of fact, a brief narrative assessment of the impact, if any, on the state's greenhouse gas emissions, a decision to adopt, amend, or repeal the regulation or take no action, include the exact text and citation of such regulation adopted, amended, or repealed, the effective date of the order, a signature of a quorum of the agency, and any other findings or conclusions required by law. So in other words, it gives the public and protects the public interest by allowing participation and resulting in a product that makes clear what the agency is deciding to do. I'm certainly happy to answer any questions that the Commission has on either our application, the Title 29 process, or the Title 26 process. But again, Delmarva would ask that the Commission adopt proposed Order 10503, proceed under the known Title 29 process, and if the Commission wants me to submit a new proposed notice with the dates I mentioned earlier, pushing this into 2025, I can do that by close of business tomorrow. Thank you.
Thank you, Mr. Jordan. Ms. Sweeney?
Chairman, Ms. Nori is going to be speaking on behalf of staff and DPA.
Please.
Thank you, Chairman Winslow and Commissioners. Mr. Jordan is very persuasive. He almost sold me on that, but he didn't, and here's why. Notwithstanding the virtues of a, quote, Title 29 process, the General Assembly has authorized the Commission in Section 201E, which of the Public Utilities Act, a section which Delmarva barely acknowledges even exists, and tells the Commission, if you are interested in alternative rate making for any of the utilities subject to your jurisdiction, and keep in mind the deregulated utilities, such as the third-party suppliers that we've heard from, are not subject to this Commission's jurisdiction for most things. This is how you go about doing it. You will proceed under Section 201E. Now, Mr. Jordan suggests that, well, that's too confusing to the Commission. I think that's kind of an insult to the Commission. It is hardly confusing. This is what the General Assembly specifically identified, and the commission is required to follow that. If and when, as here, a utility subject to its jurisdiction requests alternative rate-making treatment. Now, I heard a new argument today, because Delmarva didn't make this in its written, didn't make this argument in its written submission to you, is that, well, this is rate of return regulation, rate-based rate of return regulation. It's just for 3 years, and 3 years at a time. So that's why the only thing you have to do is change the minimum filing requirements. No, again, that's not what the statute says. So we want to be clear. We are not challenging Delmarva's right to file a petition requesting approval of alternative rate making, and we are not challenging the Commission's authority to consider such a petition, because Section 201E gives them the right to do that and gives the Commission the authority to consider it. But what we are challenging is Delmarva's utter failure to even acknowledge the existence of Section 201E as the vehicle through which its proposal should be accomplished. Its petition completely ignored Section 201E. Reading it, you would be forgiven for thinking that Section 201E did not exist, but it does exist. And it, not amendments to the MFRs for rate cases that would only apply to Delmarva, should be the lens through which the Commission examines Delmarva's petition. Now, Delmarva claims that because the MFRs do not permit fully forecasted test periods, it is required to request a change in the MFRs to propose its alternative to rate-based rate of return regulation. Now, it seems to be suggesting that there's a conflict between Section 201, which gives the Commission broad regulatory authority, and the MFRs, which reflect a decision by the Commission to exercise that authority in a specific way. But as we pointed out in our objection, our courts have long held that if there is a conflict between a statute and a regulation, the statute controls. Delmarva tries to distinguish that case that we cited by saying, well, that was a regulation versus a provision of the Delaware Constitution. And that's true. That case did involve that specific thing, but the court in that case cited a case that did involve a statute versus a regulation. So the authority is good authority. It's not distinguishable on the basis that, oh, well, we got a statute, or the Constitution here, not a statute. It's a distinction without a difference. So Section 201E would control and would permit Delmarva to request an alternative rate-making proposal that covered multiple years without the Commission having to amend the MFRs. Section 201E identifies different kinds of alternative rate-making treatments, and Delmarva actually identified some of those that are in its application. Incentive regulation, earnings sharing, those are specifically identified in Section 201E1. And Delmarva didn't really talk about them too much because that kind of cuts into its argument that this really isn't changing rate-based rate of return rate making at all. It's just that we're doing it for 3 years. No, they are making changes. In fact, when we met with Delmarva to discuss this, Delmarva called this a sea change in regulations, or in regulation of it, and we would agree with that. So why is considering Delmarva's petition under Section 201E important to staff and the DPA? Why should the Commission deny Delmarva's petition to treat this as a pilot rulemaking applicable only to it, and approve the DPA's and staff's position that the Commission be treated as if it were filed under Section 201E? And that is because Section 201E includes ratepayer protections that the Commission must find are present before it can approve an alternative rate-making proposal. And those standards are departing from rate-based rate of return rate-making regulation is in the public interest. Departing from rate-based rate of return rate-making regulation will promote just and reasonable rates. And finally, that the alteration of regulation will not adversely affect the availability, cost, or quality of the regulated utility service provided to the utility's customers. And I raise that again because of Delmarva's argument that, well, this only applies in the context of deregulation of utility services. It doesn't. If that was the case, that last standard would not need to be included in Section 201E. These ratepayer protections reflect the General Assembly's understanding that a utility might propose alternative rate-making treatment that isn't in the public interest, or that doesn't promote just and reasonable rates, or that adversely affects the quality, cost, or availability of regulated utility services. The General Assembly understood that many of our regulated utilities are investor-owned, and that utility management may not be focused on ensuring that customers benefit from an alternative regulatory scheme. The Commission would not be required to make any of these findings if it were straight-up rulemaking that Delmarva requests. And that is why it is important that this petition be examined carefully and that the witnesses be subject to discovery and cross-examination and an evidentiary hearing. Now, Delmarva has been talking about an alternative rate-making proposal for at least a year now. It has had at least a year to put its proposal together. But under its proposed schedule, comments would have to be filed by November 29th in order to be considered at a December 18th hearing. That is 139 days from start to hearing. Section 203E provides that the Commission shall have 180 days to consider an alternative rate-making proposal with an additional 90 days for good cause found. So Delmarva's proposal is depriving the Commission of a minimum of 41 additional days and perhaps up to as many as 131 additional days. Now, I did hear Delmarva's counsel say that, well, we could stretch out the Title 29 procedure a little bit as long as we get it done within a year, because if we don't get it done in a year, the regulation is deemed denied. Again, that was not in their papers, so I had nothing to respond to with respect to that. In any event, the reduction in the amount of time for the Commission to consider such a sea change in the regulatory scheme applicable to Delmarva seems unfair. So in closing, staff and the DPA respectfully request that the Commission to give them and itself what the General Assembly intended them to have with respect to an alternative rate-making proposal. We should have the entire 180 days that Section 201E gives us, with an additional 90 days if the Commission finds good cause for the extension. And most importantly, Delmarva should be required to prove that its proposal is in the public interest, will result in just and reasonable rates, and will not adversely affect the availability, cost, or quality of the regulated utility services provided to its customers. And we therefore ask you to enter the proposed form of order that we submitted and the proposed form of public notice that is attached to that order. Thank you.
Thank you, Ms. Iowari. Mr. Jordan, 5 minutes rebuttal.
Thank you, Chair Winslow. The same General Assembly that passed 201 passed Title 29. The difference is that Title 29 is clear. It doesn't require the Commission to say there's a conflict between the regulation and Section 201E. And we don't dispute that when there is a conflict, the statute trumps the regulation. The difference is what they don't cite is a situation where an agency identified a conflict and then waived it and a court upheld it or even addressed it. And that's because, as I mentioned, this title, or Section 201E, Title 26 process, it's unknown. The General Assembly was clear with Title 29. What's available And like I said, it sets the bare minimums. The commission can do more. The commission wants to appoint a hearing examiner, as we included in our application, it can. If the hearing examiner wants to allow for the submission of data requests, he can or she can. There's nothing in Title 29 that outlaws that. And when you look at the text of Section 201E, it gives the commission the authority to depart from rate-based rate of return. But when you look at the application and you look at what Delmarva is proposing with this regulation, it's not seeking to depart from the rate-based rate of return regulation. The idea that there is the earning sharing mechanism and the performance incentive mechanism are options for one of these filings. They're not required, but they're options. Is this a sea change? In the sense that it gives the commission new opportunities for transparency into how Delmarva, as the public utility and the pilot utility, would spend its money. Instead of coming in and saying, we spent this money, can we recover it? We're seeking permission first. We want to spend the money on this. Approve it or disapprove it. That's what we're talking about with a sea change. Not with anything that involves the commission's regulatory authority, not with anything that lowers the standard of proof for Delmarva, not something that eliminates the idea that something has to be in the public interest, and certainly not something that makes it easier or less burdensome for the public utility to prove that the rates it's proposing are just and reasonable. None of that has changed. The pilot utility concept, as I mentioned, was inserted because of the resistance Delmarva got from staff and DPA, but the good thing with Title 29 that's not available with Title 26, during that notice and comment period, if DPA and staff want to suggest a comment to remove the pilot utility concept, make it available to all utilities, they can do that under Title 29. They can put that proposal in front of the hearing examiner. The 180 days, as I mentioned, we can adjust that. I can do it as I mentioned. If the commission's interested, I can include the dates that I discussed earlier and submit a new proposed notice that the commission would then forward over to the Register of Regulations. And the 12-month period that I mentioned, that's in Title 29. Obviously, that's a lot more than 180 days, and it's measured from when the public hearing occurs. So the commission has ample time, in addition to the new dates, to consider this. And so when you look at the text, you look at the context of Section 201E, it does not apply. Title 29 applies. It provides the way forward, and that's what proposed order number 10503 does, and Delmarva asks that the commission adopt it. Thank you.
Chairman Winslow, two quick thoughts.
If I give you two quick thoughts, and I've heard you say that.
I know, I promise.
No, I'm going to give
90
him,
seconds.
I'm going to give him two quick thoughts because he has the right to rebuttal. So go ahead, please.
All right, with respect to the what Delmarva keeps calling the unknown 201E procedure, the only reason it's unknown is because Delmarva is the first utility to request alternative rate-making treatment. And it's not necessarily unknown. It's not, I shouldn't say not necessarily, it's not unknown. The General Assembly laid out the procedure for the standards for the commission to follow, what the company's got approved. Second, is Delmarva saying that, it claims that it will have the burden of proof? Well, burden of proof isn't really a consideration in the course of regulations. That is something that occurs in a litigated proceeding. But having said that, is Delmarva saying that with respect to these regulations, should the commission go that way, that they will satisfy the requirements that the General Assembly put into 201E for alternative rate making? Thank you.
Thank you, Ms. Iowa. Jordan, any further comment?
I'll just answer the last question from the public advocate, and the short answer, I think, is that Title 29 allows, obviously, when it comes time for the commission to make a decision, to consider, is this regulation in the public interest? I don't want to assume that when the commission does make a decision, it's always thinking that. But I will.
There are other standards besides the public interest.
What I'm getting at, Your Honor, is that, of course, the commission can consider the public interest when it's looking at a regulation, any regulation. Title 29 doesn't prevent that. It's written by the same General Assembly that passed 201E. It just happens to be clear. It applies here, and the commission is familiar with Title 29. Thank you.
Thank you, Mr. Jordan. Commissioners, do you have any questions of the parties? Commissioner Drexler.
Mr. Jordan, you didn't talk in any depth about ratepayer protections. Ms. Iori did mention ratepayer protections, including adverse costs, quality of service, et cetera. And to me, that's the main point here. And so I want you to address that, if you would. And Ms. Iori, similarly, you didn't mention under Title 26, transparency, which seems to be a theme of Title 29. So if you would, in order, just clarify those for me, please.
Yes, thank you, Commissioner Drexler. As for those protections, what Section 201E is talking about is the public interest and that the product would promote fair and reasonable rates, and the mention about the services. And when I started, I mentioned the 3 phases with Title 29. Generally speaking, during the phase when the commission has to make its decision, of course, it can consider the public interest. It can consider whether this regulation, in the commission's understanding and based on the full record that's been presented, would promote fair and reasonable rates, as well as the services. But more importantly, I think those topics are still, they're not being changed by Title 29. When Delmarva would file an application here, it still has to prove to the hearing examiner and ultimately to the commission that what it's seeking is something that will produce or result in fair and reasonable, or just and reasonable rates. The quality and reliability of Delmarva's services, whether electric or gas, are always at issue when you actually file one of these rate applications. And so it's connected to the Title 29 process. It just happens to be that it comes when we file for the rate recovery. But again, Title 29 does not prevent the commission from considering those topics. And of course, if the commission goes with the Title 29 process and appoints a hearing examiner, there is the public hearing that can be an adversarial public hearing. Delmarva is open to discovery from staff, from the public advocate, from DENREC, from anyone who participates in that period, to back up the regulation and show, as a matter of fact, this will promote just and reasonable rates. And that is something, once it becomes part of the record, becomes part of the hearing examiner's recommendation to the commissioners, and so it does get incorporated into the final product. You're welcome.
What I heard Delmarva doing was their best backstroking attempt not to say that it really would be considered as part of Title 29, and it wouldn't be, because it is not specified in Title 29 that those standards be considered. With respect to transparency, what is transparent in Title 29 is people filing their comments with respect to proposed regulations. And then the commission holds a hearing at which it discusses those comments and makes a decision, yay, nay, on the regulations, or changes the regulations, in which case you start all over again, which could also happen here. With the Title VI, and I don't want to call it the Title VI proceeding. I mean, it is a proceeding pursuant to Title 26, but that proceeding will also be transparent. People can see what got filed on the commission's website. There will be a public hearing. People can attend that. So the Title 29 procedure doesn't lend itself to any more transparency than Title 26. It's just a different procedure.
Commissioner Gray.
Thank you, Mr. Chairman. Mr. Jordan, Ms. Iori, I think there's merit on both arguments if I understood what was presented, and I'm having a little bit of problem trying to actually have the full perspective to make an informed decision. But I did hear contradictory remarks that in the case of Mr. Jordan, it says 201E does not apply, and Ms. Iori says 201E absolutely does apply. Where am I confused with those two statements, and why are you taking those positions?
You want one of us to go first, particularly?
Well, the question is for both. Mr. Jordan says 201E does not apply, and Ms. Iori says it does apply. Why am I confused?
Well, I don't think you can say that 201E does not apply. I think what.
Excuse me, that was Mr. Jordan's statement.
Okay,
Your statement was it does apply.
It does apply, and that's why I said, I don't think, when I say you, I don't mean the royal you. I don't think one can argue that Section 201E does not apply, because it does by its very language. It says, in the exercise of supervision and regulation over public utilities. Now, public utilities is a defined term under the code, and it means utilities that provide the services that are identified in Section 103 or 102 and are subject to regulation by this commission. The commission may, upon application or on its own motion, after notice and hearing, alter in whole or in part its supervision and regulation over some or all public utility products or services and over some or all public utilities to the extent necessary to promote and sustain adequate service at just and reasonable rates, where the commission determines that alternatives to supervision and regulation, including the competitive provision of such products and services, are in the public interest. Now, that says including, not including and limited to, including. What Delmarva was arguing was that, well, this section came into being during the time that the General Assembly was deregulating the electric supply function. And so you have to read it in that context. I suggest to you that that is not accurate. You read, the first place that you go is to the language of the statute. Legislative history, to the extent that it comes into play at all, only comes into play if the statute is ambiguous. This statute is not ambiguous. It then goes on to say, alternatives include, but are not limited to, incentive regulation, earnings sharing, both of which are raised in Delmarva's proposal, categorization of services for the purposes of pricing, meaning perhaps bundling or unbundling, price caps, price indexing, ranges of authorized returns, and different returns for different services. The commission is specifically authorized to depart from rate-based rate of return regulation when it is in the public interest and when such departure is found to promote just and reasonable rates. Nowhere in that section or in any of the next subsections of Section 201E does it say that this only applies to utilities who have some or provide some competitive service.
Thank you, Ms. Iori.
Thank
Mr.
you.
Jordan?
Thank you, Commissioner Gray. The statute is unambiguous when it says, quote, "The commission is specifically authorized to depart from rate-based rate of return regulation when it is in the public interest and when such departure is found to promote just and reasonable rates." That's when it applies. But when you look at what Delmarva is proposing, we're not proposing a departure from rate-based rate of return regulation. So when you compare those and you juxtapose them, that shows that Section 201E does not apply. So that's the text of it. And then I walked the commission through, well, what happens if 201E does apply and the commission has to declare that there's a conflict that exists between that phrase, rate-based rate of return regulation, and the proposed MFR. The option that Delmarva is proposing says there is no conflict because Section 201E, by its text, does not apply. And to help support that, when you do look at the legislative history, it specifically talks about deregulating public utilities, in whole or in part when the commission determines that a competitive market exists and deregulation is in the public interest. And that, I think Commissioner Drexler gets back to your question too about the public interest. They're talking about the public interest in the context of deregulation. And is the commission going to go forward with a proposal like that? And when I looked at the history of this, I could only find one example under 201E, and that was where Artesian sought an agreement with a local town to prevent a municipal annexation. It certainly does not stack up to the Title 29 process that has been used throughout the state by various agencies. Title 29, by its very text, applies. Title 201E might apply if we were seeking a departure from rate-based rate of return regulation, but we're not.
But they are. They are including in this earning sharing and incentive regulation. Those are specific examples of alternative rate making that the General Assembly gave in 201E. Honest to God, I feel like I'm in 1984. We've never been at war with East Asia. I mean, I don't know how you read 23E1 and conclude that it does not apply when a utility requests alternative rate-making treatment.
Ms. Iori?
I just don't know.
Ms. Iori?
Chairman, may I just conclude this one statement? Sure. The two responses that I received. Thank you. First of all, I didn't hear that 201E does not apply if you're staying with rate-based return on return regulation. I didn't hear that as the statute was read. It may be that you can apply that as a concept and interpretation. And I don't know that we as a commission, at least I haven't today, been provided enough information about how your proposal is going to impact the public interest in reasonable rates. And so I don't believe that I have enough information to make an informed decision in your direction, Mr. Jordan, but there is more information that could be provided to me that could convince me otherwise. Thank you, Mr. Chair.
Ms. Iori, is it your position that we have to use 201E for this application because of the alternative rate-making mechanisms that obviously Delmarva has included in their application?
Yes.
So we can't say, use our discretion and utilize Title 29?
No.
Mr. Kelleher, do you represent the commission in this matter?
I am representing the commission.
Do you concur with Ms. Iori's legal opinion or not?
I think there are arguments to be made on both sides. I'm a lawyer, so I'm sure that doesn't surprise you. There is a sort of general statutory construction argument that if there are a general statute and a specific statute, that usually the specific statute would control. Obviously, the Public Utilities title applies directly to the Public Service Commission. So while I think the commission makes either decision, gets appealed to the Supreme Court or to the Superior Court, they would probably uphold it as a reasonable exercise of your judgment either way. I think the Title 26 as a more specific statute is probably the way to go.
Thank you, Mr. Kelleher. First of all, I'd just like to say that I think that both counsel did really an exceptional job of arguing the issues and hopefully made it clear to all the commissioners about what the issues are. And it just seems clear to me that there's alternative rate making in the proposal. And to be very frank with you, it's been illuminating to listen to all this argument about the procedure, but I'm really more interested in the proposal and what staff and DPA think about it and getting to it in some fashion or another, and it looks like we're going to, because in my opinion, it looks like we have to go under 201E. And so that's the way I'll be voting. But to be frank with you, I'm much more excited and interested in hearing about the proposal and getting behind us the argument over the procedure. So, and of course, we're going to do that because we're going to vote. And then that argument will be over and we can march forward. And it's the reason I'm excited about it is because we just went through a rate case with you guys. And one of the things that we've been talking about for a number of years is more openness from DP&L, more collaboration between staff, DPA, and the company with respect to what's going to happen in the future. I don't know if the 3-year rate making is going to accomplish that or help in that regard, but it has that possibility, certainly, because if we're looking at 3 years, that means staff and DPA will be able to look out with you and see what you're doing, and you guys can work out that future, hopefully together. So I'm going to move that we sign the order argued by Ms. Iori on behalf of staff and DPA. If there's a second, we'll discuss it.
I second.
Is there any discussion on the motion?
For the record, that's order number 10504.
Yeah.
Yes. Thank you.
Any discussion? All those in favor signify by saying aye.
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 It's 4 ayes and 1 absent. The motion carries. Mr. Jordan, you and I are going to miss Iori soon. You know, we're going to miss her.
Yes, we will.
Yes, we will. That's a unanimous decision that we will. Thank you all very much. We have a hearing scheduled next in the matter of the petition of the Public Service Commission staff, Division of Public Advocate, establishing a regulation for distribution system investment plans. And we have Public Service Commission docket number 18-0935 to discuss, and we have some extra parties that we need to welcome to the table. Mr. Noyes, thank you so much for being with us, and who is that to your right?
My name is Sawyer Traver. I'm a Deputy Attorney General here representing DNREC today.
Okay, I have to apologize. I didn't catch your last name.
Traver.
Oh, Traver, okay. Just like it says in my paper. So,
I'm going to ask you folks to pull in on the mics really close so that the folks outside can hear us.
I think we're going to be starting on this one with Mr. Jordan again.
Good afternoon, Mr. Chair Winslow and Commissioners. Brian Jordan on behalf of Delmarva Power and Light Company, and I am joined today on my right by Amber Young. She will be providing any substantive commentary that we need to take care of in front of the commission, but I would note that staff and the DPA filed a request that the commission put this docket on hold while the parties, meaning Delmarva staff and the public advocate, and the commission reaches a final order on, I don't know whether to call it the Title 26 process or what we just handled, but until we get a final order on that to stay this matter. Delmarva fully agrees with it. We think it's a wise choice. Trying to read the tea leaves here, gaze into the crystal ball. Some of the items that the commission would have talked about today with this ISR process and these proposals are things that might end up in the final product with the previous docket, and rather than run the same play twice, it certainly makes sense to Delmarva, and Delmarva supports the request to put this docket on hold and let us sort it out on the other docket.
Ms. Sweeney?
Thank you, Chairman Winslow. Yeah, so as background, the proposed changes to the regulation were published in the July Register of Regulations. And as the Commission's well aware, as we've even discussed today, staff and DPA have taken exception to Delmarva Power's Electric Infrastructure Safety and Reliability, ISR, plan for the past 3 years. So The intent in revising the regulation was to make that ISR plan and process more meaningful for the commission and regulated utility customers by requiring utilities to more thoroughly document the rationale behind their capital investment strategies. And we appreciate, staff and DPA appreciate Delmarva's review, their initial review of the proposed regulation. Parties have met, able to come to agreement on many issues, particularly filing dates, subsequent review dates of the ISR and the long-range distribution plan processes. And staff and DPA do feel that Delmarva's alternative form of rate regulation filing, I'm not going to call it the 26 process, but their filing should be resolved prior to making any changes to the regulation because the AFRR may impact staff and DPA's proposed changes to the regulation.
Thank you, Ms. Sweeney. Ms. Travers?
Thank you. Yes, in regard to the matter discussed, the State Energy Office wishes to concur with the recommendation that the Commission take no action on Regulation 3007 until a final order is issued regarding DPL's petition. We look forward to working with staff, DPA, and DPL on this matter.
Thank you very much. Commissioners, do you have any questions? Maybe we can have a motion?
Defer action on this item.
Is there a date that we're going to defer this to, or
I don't think that we'd actually discussed a date.
until the call of the parties to have it placed on the calendar?
Yes.
I second.
Is there any discussion on the motion? All those in favor signify by saying aye.
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 Any opposed? Motion carries. Thank you all very much. Mr. Noyes, since you're here, and we enjoy having you here always, is there anything that you'd like to impart to us about what's going on in the world of DENREC and it being
Well,
forward?
thank you, Mr. Chairman. Very quickly, first of all, you have just welcomed Sawyer Traver as our new DAG representing us, and she has certainly been immersed in some pretty arcane procedural matters here this afternoon. Second, if I could, Scott, if you could come up here, I'd like to introduce you to a new member of the State Energy Office team. Scott Hunter joined us on Monday after a career with the New Jersey Board of Public Utilities in the Office of Clean Energy as a program administrator, and we're happy to have him here. And he's going to bring, we're confident he's going to bring some significant background and expertise to the considerable amount of work we have in front of us. And finally, Mr. Chairman, want to mention relating to, you of course have been engaged, as some other folks at the table have, in the Governor's Energy Advisory Council. And as those familiar with that process know that the Governor's Council has proposed a set of recommendations, and the State Energy Office is taking those recommendations and turning those into an updated state energy plan. And some of you have been in the room when we have briefed on that process. As part of that process, we are going back to the public for some more public engagement sessions, and that's in 2 weeks. August 13th at the Cheer Community Center in Georgetown, that's Tuesday. Wednesday, August 14th at the Route 9 Library and Innovation Center, and August 15th at the Dover Public Library, all from 5 to 7. These will be interactive. We'll have tables arrayed by subject matter, and people will be able to talk directly with us and offer their opinion to us directly and in writing on where we're going with a new updated state energy plan. And anyone interested in that, we encourage public engagement. So that's what I have this afternoon. Thank you, Mr. Chairman.
Thank you, sir. Mr. Hunter, welcome aboard. A step up coming to Delaware, I can assure you.
If I may, a biographical detail, Mr. Hunter has roots in Delaware, and those roots have led him back here, and he's now living in Lewis, which I thought would interest you.
So he's a neighbor of mine, is what you're saying.
Yes.
Well, not everything is good then, Mr. Owner. Okay, Ms. Travers, thank you very much. And gosh, where are we now? You got me all off the thing here. So I guess it's Mr. Hardigan.
Thanks, Chairman Winslow. I did want to mention, after our next meeting on August 21st, we will have some light refreshments to celebrate not only Ms. Iori's retirement, but also our pipeline safety engineer, Bob Shafkin, who's also retiring at the end of August. So look forward to seeing you then.
Okay, I guess nothing else, right? We're adjourned. Thank you all very much.